Before we begin, we would like to kindly request our guests to please put our cell phones on silent mode. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. All praises be to Allah, for it is only because of His great graces and blessings that we may gather here today. Our best greetings and salawat are also presented to beloved Prophet Muhammad Sallallahu Alaihi Wasallam. Good morning, our distinguished speakers, Dr. Nadia Naim, Dr. Iwood Clay, Professor Peter Meze, who will be joining us all the way from Hungary, Professor Budi Agusiswandi, the representative of Hukumonline, the Honorable Chancellor of Universitas Islam Indonesia, Professor Fatul Wahid, the Dean of Faculty of Law, Universitas Islam Indonesia, Professor Budi Agus Riswandi, the Honorable Vice Deans of Faculty of Law, Universitas Islam Indonesia, the Honorable Head of Department, Faculty of Law, Universitas Islam Indonesia, the Honorable Heads of Study Programs, Faculty of Law, Universitas Islam Indonesia, the Honorable Secretaries of the Department and Study Programs, Faculty of Law, Universitas Islam Indonesia. Our beloved guests, beloved students, welcome to the International Seminar on Interface between Copyrights and Journalism in the Digital Transformation era, jointly administered by Faculty of Law, Universitas Islam Indonesia, and Hukumonline. Ladies and gentlemen, distinguished speakers, our beloved students, commencing our agenda this morning, let us begin by listening to the recitation of Holy Quran by Mr. Zaki Taqiyuddin. To Mr. Zaki Taqiyuddin, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. هو يحيي ويميت وإليه ترجعون. يا أيها الناس قد جاءتكم موعظة من ربكم قد جاءتكم موعظة من ربكم وشفاء لما في الصدور وشفاء لما في الصدور وهدى ورحمة للمؤمنين. قل بفضل الله وبرحمته فبذلك فليفرحوا. قل بفضل الله وبرحمته فبذلك فليفرحوا هو خير مما يجمعون. صدق الله العلي العظيم. السلام عليكم ورحمة الله وبركاته.
Thank you, Mr. Zaki Takiuddin. The following agenda is singing the national anthem Indonesia Raya and the hymn of UII. For that, we would like to respectfully request our guests to please stand up. you. Please be seated. The following agenda is the opening remarks from the Chancellor of Universitas Islam Indonesia, Professor Fatul Wahid. To Professor Fatul Wahid, please welcome.
Assalamualaikum warahmatullahi wabarakatuh. A very good morning to all of us. Alhamdulillah wa syukur ala ni'amillah wa salatu wassalamu ala rasulillah. La hawla wa la quwata illa billah. Rabbi israh li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. The honorable invited speakers, Dr. Wood Clay, journalist and editor of the Kanttekening from the Netherlands. Welcome to our campus, Doctor. Dr. Nadia Naim from Aston University, United Kingdom. Professor Peter Meje, who will be joining us soon with online platform from University of Szeged, Hungary. Prof. Budi Agus Swandi, who is also the Dean of the Faculty of Law, Universitas Islam Indonesia. Ibu Farah, the chairperson of Hukumonline, and all the crew. My colleague, the Vice Dean, the Head and Secretary of the Department, the Head and Secretary of Study Program, the Professor, Prof. Sefriani, from Faculty of Law, Universitas Islam Indonesia, dear student and all the participants. First of all, I would like to extend my warm welcome, especially to our guests, Dr. Ewot and Dr. Nadia, to our beloved university, Universitas Islam Indonesia. I would like to take this opportunity to tell you a bit about our university. Universitas Islam Indonesia was established before the independence of this country in 1945 in Jakarta, the capital. But then during the revolution at the time, in the beginning of 1946, the capital of Indonesia moved from Jakarta to Yogyakarta. At the time, our university, at the time, its name was Sekolah Tinggi Islam, moved from Jakarta to Yogyakarta because of tourism. The first one is because of the situation in Jakarta, which was not so conducive for learning at the time. And the second one, because of almost of our lecturers at the time were the official of the national government. So including the first vice president, Dr. Muhammad Hatta. And now we are still in Yogyakarta, although the capital already moved back to Jakarta in the beginning of 50s. And now we are the home for more than around 30,000 students coming from all corners of Indonesia and from more than 20 countries around the world. And today we are happy to host this international conference. And the theme selected by the committee is very timely and important to me. An interface between copyright and journalism in the digital transformation era. I have to confess that my educational background has nothing to do with journalism and copyright. I'm from the Department of Informatics, so at least I can relate myself with digital. And I among who believe that every technology created by human always came up with two sides, the positive and negative side. You can call it a dialectic. You imagine you have a knife. With a knife, you can save the life in the operating room, but also with a knife, with the same knife, you can kill the people. This is also the case for the internet, information technology, social media, and so on and so forth. So we will see like a paradox. A paradox. For example, I have a short list of paradox that uh, can be found in our daily life. For example, in connection with this theme of the conference, like open access versus copyright protection. This is a paradox. And the digital age already enable us to have open access to information, but it also raises a concern about protecting copyrighted content from unauthorized use and distribution. Another paradox, for example, between democratization of information, when everyone can create and disseminate information, but in another side, you will have misinformation. It's a paradox. Another paradox, global reach versus jurisdictional boundaries. This paradox could be relevant to our discussion today because uh, the copyright legal system, it could be diverse, not the same, exactly same between one country to another. But when an information and journalistic work or journalism, what call it, piece transform in the digital platform, we cannot limit only in one state or in one country. It can easily cross the border. So we have problem about the copyright legal system in very different countries. Another paradox could be about speed of publication in the context of journalism and fact checking. This kind of hoax, misinformation. So in one side, we would like to have very fast information that came to us. We expose the very newly published information. But at the same time, the quality of that information could be questioned. Is this true? Is it valid? Or is it hoax or misinformation? And I think you can also make this list longer, the list of paradoxes that brought with by the advent and the development of information technology, especially internet, and more specifically social media. For example, about the creative common licensing versus commercial interest, between archiving and preservation versus copyright restriction, and so on and so forth. You can edit. But then, how we should mitigate this problem of paradoxes? So we need to think about the solution. So what came up with my mind is about balancing. It's about finding the trade-off, the, the best combination, because we have to consider so many things to come up with the most plausible solution that can be accepted by a wide range of communities. For example, about we can name about this possible solution, clear copyright guideline. Nah, this one solution. Another solution could be about robust fact checking system. If we are talking about the misinformation, hoax, and so on, How about a collaboration with copyright holder? It could be also another possible solution, and a global copyright harmonization that can what call it involve more than just one country to think to find the best solution to harmonize copyright legal system, and also balancing about the freedom of expression and copyright. So I think this platform, the international seminar, will serve as a good platform to discuss this idea, to exchange the expertise between the speakers and also with the participants. And I have to stop here because I have to be very aware, not pretending to be the first speaker. I only gave my opening remark, and that's why I extend my gratitude to all the speakers, the participants who have shared the time and expertise. And I do hope and believe that your presence and engagement are very important to make this conference seminar as a platform for meaningful discourse and exchange of ideas. So with the hope to go blessing from Allah, let's together open this conference by reciting Basmalah. Bismillahirrahmanirrahim. And I wish that you will find this seminar personally rewarding, socially enriching, professionally relevant, and intellectually enlightening. I thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor Fatul Wahid. Ladies and gentlemen, on to the core agenda of our event this morning, which is the panel discussion by our distinguished speakers that will be led by the moderator, Miss Indah Rahadian, SHMH. Miss Indah Rahadian currently serves as permanent lecturer of Faculty of Law, Universitas Islam Indonesia, with the area of expertise in financial and technology law. She is also the director of Capital Market Research Center, based here in Faculty of Law, Universitas Islam Indonesia. She graduated her bachelor degree in law and masters of law in Gajah Mada University, and she has just recently defended her dissertation also in Gajah Mada University, Yogyakarta. Ladies and gentlemen, please join me to welcome Miss Indah Rahadian, SHMH.
Okay, thank you, Miss Gemilang. Assalamualaikum warahmatullahi wabarakatuh. Good morning to all speakers, guests, and all our international seminar participants. Uh, Ladies and gentlemen, related to what Professor Fatul said, that the development of information and technology has changed many or various aspects of our life. If we're talking about the digital transformation, especially the effect in the business sector, that's really close with our life, yeah, daily life. And if we talk about the journalism or in the journalistic world, digital information that shortly defined as the process. Digital transformation is a process of adapting the digital technology by organization in order to make the new or to make the new or to modify their product. Yeah, if we talk about the business, it means that modify their products, their services, and also their operation. And also in the field of journalism, digital transformation provides so many advantages. Like the main advantages is about efficiency. That digital transformation could make every kind of journalistic works being so fast and efficient. But also on the other hand, digital transformation creates many legal challenges. The main legal challenges at least related to two kind of questions. First is about how to create sufficient regulation, and the second one is how to protect the parties, like how to protect the copyright holders and how to protect the publisher, for example. To discuss this topic, ladies and gentlemen, today we have four excellent speakers. The first is Dr. Nadia Naim. Good morning, Dr. Nadia. And then next is Dr. Ewot Klee. Good morning, Doctor. And we also have our beloved professor, Professor Budi Agus Riswandi. Good morning, Prof. Also will join us with the platform Zoom meeting, Professor Peter Meze. To all the speakers, I invite you to come to the stage. Yes, please. Yeah. Give big applause for our speakers. Yeah. You can. Okay, ladies and gentlemen, our first speakers will be Dr. Nadia Naim. I will briefly read Dr. Nadia background. Name is Dr. Nadia Naim. She is senior lecturer in law and technology in Aston Law School, Aston University. She also has so many publications. At least I noted more than 20 publications, both in international journal article and also in work of paper conference paper. And also she got the awardness from full scholarship from the BPP for the BVC with further scholarship from Lincoln Inn and Garden Court Chambers. Please give big applause for Dr. Nadia. Yeah. Dr. Nadia will deliver her speech on the topic copyrights protection and publisher rights within the framework of the United Kingdom legal system. Okay. Probably it's okay. Use the podium. Okay. Yeah. Dr. Nadia, you have around 20 minutes to deliver your speech or to do your presentation.
Oh, I'm gonna hold it. Good morning, everybody. Assalamualaikum. I'm Dr. Nadia. Thank you. I'm Dr. Nadia Naim, and I'm from Aston University in Birmingham, in the UK. So, some of you I've seen yesterday. So you get me twice. Lucky you. Today, I'm going to talk about copyright, the protection available within copyright within the UK English legal system, and also when we're thinking about the digital transformation era. So when we think about the impact of digitalization, we think about artificial intelligence and the impact that has had on copyright. So what I would like to do is start off by talking to you about what copyright is and how it works as an intellectual property right. So in terms of how intellectual property rights work, there are different types, and the most relevant for journalism is copyright, because copyright is how we protect our expression of an idea. So copyright does not protect an idea. Anybody can have an idea and you cannot monopolize it. However, what copyright allows is your expression of an idea. It's known as the idea expression dichotomy. And what that means is that the work that you create must belong to you and it must be original. So originality is quite a low standard in intellectual property, as long as you can make sure it fits within one of the categories of a work. And in relation to journalism, your most important category is publishing. It's your publishing rights, it's your literary works. So if you could just move to the next slide. Thank you. Thank you so much. So in terms of the author is the intellectual creator of work. And the standard is that you must fit within a literary work, a published work, artistic work, or music work. And it must be fixed in a tangible form. So that means you have to be able to write it down, you have to be able to record it, or you have to be able to visually represent it. And then you have your copyright. And then what that allows for is multimedia use, it allows for streaming, and it allows for several outlets for that use of your copyright. Now, copyright is a pretty good intellectual property right, because you have the right to copyright for your entire life. So the monopoly belongs to you, plus 50 to 70 years. In the UK and in Europe, it is the lifetime of the author plus 70 years. So that means if you write a best-selling book, which sells millions of copies, all of the rights belong to you, economic and moral rights. So economic are your financial rights, and moral means nobody can change the wording or the meaning of your book without your permission. And therefore that allows you full control over your rights as long as you keep them. If you sell them, that's different. But if you keep your copyright, it belongs to you for your entire life plus 70 years in the UK. In other countries, it's plus 50 years. So it varies, but it's a minimum of 50 to 70 years. Now, the real gem of intellectual property law is that we have the World Intellectual Property Office. So that means, as a standard, anybody that is a WTO member must have WIPO compliance and adhere to the TRIPS agreement. So all signature countries have a minimum level of TRIPS compliance, which is great for intellectual property, because when you are filing for protection in another country, you can expect the same minimum standards. It's something that other areas of law really need, because it really helps you to know what you're going to expect from another country and what protections that you will receive. So thinking about what is copyright, not everything is copyright. So if you could please move to the next slide. Thank you. So there's no protection for ideas, but the expression of the idea. There's no protection for mere information or facts. So if you are a historian and you are going through different facts and figures and you are collating that, that is not copyright, because that is public information. Once you have something that is beyond an idea, beyond mere information and more than facts, then you can get copyright. In the UK and EU, copyright is automatic. So as soon as you put pen to paper, or as soon as you type onto your laptop, or you record using your phone or a camera, you have automatic copyright. But it's easier to provide proof of your copyright. So if you are writing a book or you're creating music, you need to put your copyright symbol on, your name and the date. And then that helps evidence where your copyright comes from and how it belongs to you. So that's really important. So you have to show that it's original. You have to show that it fits within what is defined as copyrightable, and then you have to fix it. So you have 3 steps to the test to give you copyright. Now, most, as you see in art, copyright, you can, from more very obscure art, can have copyright. In books, you can have copyright. In poems, in literary works, in a transcript, you can have copyright. In magazines and in journalism, in newspapers. There's a lot of opportunities for you to create your own copyright, and then the value depends on how you can market your work, right? So next slide, please. So thinking about sound recordings, copyright isn't just belonging to one person. So if you have a song from the singer Valerie and the sound recording falls under Section 5 of the Copyright Design and Patent Act 1988. So the recording of sounds, which the sound may be reproduced, or recording of the whole or any part of the sound, excludes mere copying. So copyright vests in the producer for the sound recording and exists separately for the copyright in the work recorded. So Section 3, copyrights in Valerie are sung by Amy Winehouse. The copyright is to the lyricist, the Zootons, and the copyright to the musician is Amy Winehouse. The copyright to the recording produced is arranged for the recording by Mark Ronson. So you can see in one song, there are lots of different owners of the copyright. We only see the singer, so we think, all of this copyright belongs to the singer. So if any of you are aspiring musicians, I recommend having all of the copyright yourself. Produce it, record it, sing it, then all of the copyright belongs to you. Now, the value of IP is constantly changing. So there was a popular TV show in the UK called Stranger Things, and they played a song from the 1970s. And at the time, the lady was making very small money in streaming. When that song got played on the Stranger Things, her streaming went up to £250,000 just on Spotify. She owned all of the copyright. She was a very smart woman. And as a result, her earnings went up into the millions again for a song that nobody was listening to for 30 years. So try and be really, really business savvy with your copyright and own as much as it can. When you are signing any contracts, make sure you read the contract and you check what rights you are giving away and what rights you are keeping. So it's similar again with other areas. So in films, you have the same thing. You have different levels of copyright assigned to different areas of it. So in terms of how that works for protection, if you could just skip 2 slides, please. One more. Thank you. So in terms of how that works, we have a 2-stage inquiry at the infringement level. So has a substantial part of the work been copied? This is objective. So we look at both quality and quantity. So if you copy the whole thing, then yes, it's copyright infringement. If you copy certain parts, what is the quality of the copying? How important is it to the copyright initially? And then that dictates whether there is a causal connection, which is subjective, and where there is intention to copy, or if it's primary or secondary. We also have other sanctions like contributory negligence and criminal liability. So there's a lot of infringement issues with copyright. Anyone that has copyright of value will sue. They will go to litigation and they will try their best to stop you from using their copyright. They will also fine you. They will also destroy any goods that you've created that have their name on it. So it's very, very powerful copyright infringement. And it really protects the copyright owner, because what is your incentive to invent or create or make copyright if you can't protect it? So you put a lot of time and effort into creating your copyright, so you want it to be protected, right? So you want to have that protection in what you do. So that's really important. There's also defenses. So if you could please move to the next one. So you have defenses as well. So there's fair use, which I'll explain in a second. It's no longer copyright. Is it in the public interest for you to use somebody's copyright? That can be a defense. and also parody. So parody is where you are making fun of somebody's copyright, but in itself is copyright. That's the real beauty of copyright. So if you can take somebody's work and then you can express it with your own personal touch and your own creativity, you created new copyright. So you don't need to copy somebody's copyright. You can be inspired by it and create your own. That's the whole idea of sharing the knowledge so that we can create more copyright. And there's an economic benefit to that for the knowledge society, and it increases the overall economy. There's issues around multimedia, open source, culture, and cloning software. So there's a lot from the digital transformation era that is impacting copyright law and how it is being used. And that's why you'll see lots of strikes at the moment from actors in America, the SAG strikes going on. There's lots of strikes because what AI is now doing is it is almost replacing your writer, your actor, your screenwriter, and then the issue is that AI is supposed to be enhancing copyright or supporting copyright. It's an assisted tool. It shouldn't be replacing copyright. But in terms of defenses, I'll just give you a few examples of what the potential defenses are as well. So if I just move to the next one. So you've all heard of Harry Potter, the most famous magical boy wizard in the world. Okay, so Michael Gerber wrote Barry Trotter. Sound familiar? A bit like Harry Potter? Copyright infringement? Maybe? Is J.K. Rowling mad? A little bit? But Barry Trotter was a parody of Harry Potter. So Barry Trotter is not copyright infringement. It's a real book if you want to read it. And then we also have other defenses such as current news and fair use in how we report. So when Princess Diana passed away in the 1990s, the Muhammad Al Fayed, who was the father of her boyfriend, had security cameras all around the house, and the security guard leaked those pictures to one of the newspapers in the UK. So Muhammad Al Fayed sued because said it's copyright infringement. They didn't have the right to use those pictures. They were taken on his security cameras and they belonged to him. So technically copyright infringement, but the court held that even though it was a year after Princess Diana's passing, it was still current. So if it's current news, if it's current affairs, then you have a defense. So the newspaper didn't get sued for copyright infringement. Muhammad Al Fayed was not happy, but that was the decision of the court. And then also the very famous Tom Cruise, Mission Impossible, that you're all aware of. So he is a big Scientologist. And in his picture, there is the Reverend Hubbard, who is the leader of Scientology. And in a critique of his work, large chunks of extracts from Scientology were taken to criticize them. And he sued for copyright infringement because he said they've taken my words without my permission and taken it out of context. And again, the court said this is a fair use of his words because he is a religious figure and you can critique his work. So that's debatable. So imagine, that happening with another religion or in another country, the courts could feel very differently. But these are some examples of defenses. So not every copyright infringement will lead to success in court because there are defenses. So thinking about how that works in the current context, copyright needs to have an author. So it has to belong to somebody. So at the moment, the CDPA, which is the Copyright Design and Patent Act in the UK, under Section 9, says the author in relation to a work means the person who creates it, therefore a natural person, right? So you have to be a human being to own copyright. But in the current context, we have artificial intelligence and the impact of artificial intelligence on the digital era. So if artificial intelligence is now creating Barry Trotter, or it's now writing newspaper articles, or it's critiquing religion, who owns the copyright? who do we critique for it? Or who do you sue? And what is the defense? So there's a lot of issues around copyright and how we protect it. So at the moment, anything around the digital era, artificial intelligence, it is protected only if there is a human creator involved. So if you are using ChatGPT to write your next article, or you are using artificial intelligence to give you all of the details of your article, if you are involved in that instructions to the artificial intelligence, then you are drafting it, you are checking it, you are editing it, it can belong to you. Although that is a bit, how do you define the skill, labor, judgment, the effort? Typing into a computer to say, write me an article of 1,000 words on the strikes in America on AI is asking the AI to do your job. So it's interesting in terms of how the AI and copyright is happening. But then the biggest part of all of this is that at the moment, all the countries, US, are saying that copyright has to belong to a human owner. It cannot belong to a computer. So it cannot belong to artificial intelligence, or it cannot belong to a monkey. So can you skip a few slides for me? I think I'm out. A few more. Keep going. One more. This is it. Okay. So some of you have seen this already, but there is a very famous monkey who managed to take a selfie. Okay. So this is the monkey who clicked the camera and took a selfie of himself. So PETA, which is a famous animal protection organization, said the copyright should belong to the monkey because the monkey took the picture, right? The journalist, the photographer at the time, said that I set the camera up, I put it on a tripod, just like we have a tripod here. I put the camera on, I had everything ready to take a picture of the monkey. The monkey happened to take the picture, but the copyright belongs to me. So who does the copyright belong to? The monkey or the photographer? Or no one? What do we think? Tricky, right? Well, it has to be a human. So it can't be the monkey, right? The photographer didn't take the photograph. So can it belong to the photographer? Not really. So no one really got the copyright for the monkey selfie. But the idea is, who does it belong to? And then next, we're in this world of AI, where we're using artificial intelligence to assist in copyright protection. But if the artificial intelligence does everything, then you can't have copyright protection. And that's really where we're at with copyright at the moment. So if you move to the next. So there's a lot of AI legal challenges in copyright law. So what we have, just a few more, one more. Thank you. So we have lots of different tools for creating artificial intelligence. So if you put into DALL-E 2 system, please make, well, not even please, teddy bears working on new AI research on the moon in the 1980s. You get teddy bears, we can see that. We've got 1980s computers and they're on the moon. Pretty good, right? So that is created for you using AI, but you can't copyright it because every time you put those instructions into the AI system, it will give you the same picture until there's more data that goes into it. So you really got to think about the biggest challenge in copyright law at the moment is artificial intelligence. It's the use of AI in copyright law and how it goes from an assisted tool to an AI generated tool. And then we're in the realm of, does AI deserve, or is AI entitled to its own copyright law? So that is my final comment to leave you with. Thank you.
Okay, thank you so much for Dr. Nadia. And based on the Dr. Nadia presentation, I noted some important points, I think. First is that the copyrights must be original, originate from an author, and must be fixed in tangible form, must fall into category of recognized or protected work. And then also the copyright should belong to human. I think it's quite interesting subject matters, yeah, or interesting issues that I think that all of the students also have a lot of questions in their head related to the theme of AI in the copyrights. Okay, that copyrights should belong to human being, not belongs to non-human being like artificial intelligence. And the biggest challenge in this copyright protection in the using of artificial intelligence. Okay, and we are now moved to our second speaker. Our second speaker will be Dr. Ewart Clay. I will briefly read her profile first. Uh, his profile, sorry, name is Dr. Ewart Hans Clay. He is a journalist and also writer in a company, the Netherlands. Okay. He also got an awards in 2005. The name is the Radix Award. See, he also done with the four books publication. Without any further ado, Dr. Ewart Clue, you have 20 minutes to deliver your works or to do your presentation. Yeah, please.
Very handy. Most technical person in the world, but and then I have to give talk about technology among other topics. I hope soon my presentation will be on that side or that side. So, but yes, it is. Um, I'm not a lawyer. I've studied history, so I cannot tell you about all the legal things that a professor explained, Naim. So I will talk more about the practical perspective as a journalist. You can do the next slide, please. Now, about me, not too long, of course. I was born in 1401 to the Christian calendar 1981. And yeah, if you are following the calendar of the French Revolution, it's 192. So yeah, as a historian, you can, of course, thank you. Oh, I'm a little bit tall, I'm sorry. Um, in Groningen. In Groningen also I did my master's, my university studies in history. I did a PhD officially in theology in Kampen. That's a small provincial town. And now my expertises are politics, history, and as a journalist, I also write about multiculturalism, Islamophobia, racism, decolonization, human rights, and press freedom. So, yeah, as a journalist, I write about a lot of topics, but as an academic, my expertises are Dutch history and political history. So now, yeah, now you know, yeah, what you can ask later. Just so not too difficult questions, please. Otherwise, yeah, I have to decline the answer. Next slide, please. Thank you. Now, one of the challenges as a journalist about copyrights is the copyrights of photos, and because if you are writing for an online magazine or yeah for magazines in general, yeah you have to be very careful if you yeah don't use photos with copyrights. Otherwise, you have to pay the photographer or an institution, and they can fine you if you didn't do that. Now, last year, 2022, yeah, there was a little incident. My former colleague, Arnoud Maat, now writing for Elsevier, that's also a Dutch magazine. Nou, there's a big discussion in the Netherlands about Black Pete, Zwarte Piet, perhaps also known here in Indonesia. It's a racist stereotype of black people, and he is the servant of Sinterklaas. Sinterklaas is practically the Dutch Santa. Yeah, perhaps yeah, historically Saint Nicholas, the saint, and he gives every year at December the 5th gifts to children. And now there's a big discussion about it in the Netherlands, faded away now, but then also yeah, white people from the province, they found also that Zwarte Piet was racist. And there was a beautiful, very funny picture of two older guys, one with a belly, and they had shirts and were really not activists. Zwarte Piet is racisme, Black Piet is racist. And my colleague was thinking, oh, that is from a local website and nobody has heard from the website. So I post this picture. It was also on Twitter, on Facebook, everywhere. I posted, I will post it on our website, the kanttekening. But he didn't realize that, yeah, that the photo, yeah, it was not copyright free, and also that yeah, that medium was not pleased at all, of course, that we used it without their permission. So they fined us with a fine of 600 euros, and also we have to remove the picture. So it was yeah, the picture was funny, but the lesson we learned was not funny at all. But yeah, you should be very careful. Now, most times, yeah, in the past, also with colleagues of mine who were not very careful, yeah, we learned also new yeah, editors of our magazine is that you cannot use photos of ANP, that's the Dutch press agency. They have a big photo archive, and yeah, you can use a lot of photos. If you are subscribed to ANP, then you can use that photos. But if you, and that costs, of course, a lot of money. Now we are a small magazine, so we don't have that rights. And yeah, big magazines have, like the Volkskrant or NRC Handelsblad. So, but they're also be quick in discovering that you are using their photos without authorization, and then you get big fines. It happened to me one time when I was writing for another magazine in the past. It was, I think, 700 euros, and yeah, then I have learned my lesson. But you should be very careful, especially with them. And also, that is a little bit tricky for journalists for small websites. You should be very careful with Wikipedia and also Pixabay. Yeah, you perhaps think, oh, those pictures there are copyright free. Most times they are, but there are a lot of rules, like you have to yeah, give it to the author. Sometimes you have to put in a link, and yeah, sometimes you have to yeah, make a link to the original source. And sometimes, despite the fact that the picture or yeah, the photo is on Wikipedia or on Pixabay, it's not rights free, and then you get yeah, still you get the fine. So yeah, that is problematic. And also in the Netherlands, most times when there is a court case, yeah, the people who are complaining about that the copyright is stolen, they are most times right in those cases. So you should be very careful. Now, an example, the website Historique, that's a small history website. It is, yeah, one person has his job to manage that website, and all the other people are freelancers, but they have to pay 1,400 euros. That's a lot in the Indonesian currency. To pay a fine, and they went to court, but that didn't help at all. Next slide, please. Now, there are a couple of solutions, however, to avoid fines. Now, about Historique, the website, they went to court, but that was not a smart decision because the court, they say, you are a little bit right because the person whose photo was taken by accident, it was an accident, it was not on purpose. He asked for a tremendous amount of money, 1,500 euros. So the court says you have to pay just 500 euros, but also Historique has to pay half of the legal costs, and it means that it was not 1,500 euros for them, but 1,400 euros. So it was not a big difference. So then Yuri Fischer, he is the CEO or the owner of Historique. He decided for a time to remove all the photos of the websites, and then with every photo he was checking, is it rights free or not. It took a very long time to discover it, but he was very afraid that there would be legal claims after this incident, and he will go bankrupt because this is a small company. When you have all those legal claims, if you are a big newspaper, let's say the Volkskrant or NSC, the two most important Dutch newspapers, then of course it's not fun that you have to pay a fine of 1,400 euros, but you will survive. But for small websites, that's not the case. So you should be very, very careful. Now, there was also another small outlet. They used illegally photos of Associated Press. That is an international press agency that came before because first they had a subscription on photos of Associated Press, but then the subscription expired, but they were still using those photos. And in contrast to the Dutch press agency ANP, they are very tough in giving fines. Associated Press was more lenient, and they get a settlement. So they have to pay a fine, but it was not very, very high. And also the outlets could still use that photos which were already there. So if a company is more or an institution is more lenient, you can of course negotiate, because if you are going to court, there's a chance that you also have to pay all the court costs, and that is very expensive. Now, but more important is, of course, not to do damage control, but to prevent. Now, and one of the best ways to prevent these kind of fines is to make screenshots, of YouTube videos, and then you can make a lot of good pictures. Sometimes it's a little bit washy, so you have to press on the print screen button on the right time. It's of course a challenge on zich, but then you get a lot of copyright free pictures, and sometimes the quality is not the best, but it helps you, especially when you are making a lot of articles for a news website, to do that. So that really helps. Of course, you should still be careful, because if you are, let's say, make a screenshot of a photo that's also in the ANP archive or Associated Press or Reuters or something else, you still have to pay the fine, because then you are saying, yes, it's a screenshot from YouTube, but you are de facto you have copied an existing photo with copyright. So you should still be careful, but it is a way to have good and interesting pictures and not pay fines. Now, the most safe way, of course, is to make your own photos for the site. Yeah, of course, you can. Yeah, it's not always possible. Yeah, if there is an earthquake in Greece, for example, it's a little bit expensive. First, go with the plane to Greece, make some photos, then go back and make the good photos. So, of course, you cannot do that. But yeah, a lot of articles of course, are about standard topics like yeah, wearing a headscarf, you can photograph yourself or some people in the streets. Of course, sometimes you have to ask for permission because yeah, it's not allowed, of course, to make private photos, use them for the public. But if there are public gatherings, of course, it's public and you can make photos. Or let's say about cars, you photos of cars, and then you have a lot of yeah, copyright photos. Yeah, you can put one slide back, please. Yes, that one. Yeah, that photo is made by me. Yeah, you can. Oh yeah, also there. Yes. It's a little bit boring, but it was on a demonstration of Kurdish people in the Netherlands. They were demonstrating against President Erdogan a couple of years ago. I think it was about the invasion of Afrin in northern Syria. But there were a lot of police force was present, and I photographed two police officers on horses. And yeah, this photo, we use it a lot if it's about the police. It's a sort of stock photo of our website now, because first, yeah, if you want to write about Amsterdam, you have yeah, all the Amsterdam buildings in the background, the houses with the gevels. Now, if it's about the police, you see two police officers. You can also write about horses. You have two horses. So it's multifunctional. But of course, if it's always the same picture, I think also readers get bored. So you have to make a lot of pictures of your own about those boring topics, like police or something. Next slide and the next, please. Yes. Oh, one back, please. I'm sorry, I was too fast. Back. Yes. Sorry. Oh yeah, what you also can do is that was thanks to a company event. We yeah, if you have a company event, you can do something fun, and we did we were making paintings. Now I'm not a great artist, but yeah, my talents are in other things in life. But yeah, I was a little bit creative, and one of my colleagues was saying, "Oh yeah, if we are writing about abstract issues, we can also use our paintings. We have also our own copyrights with that. So yeah, you can also think about it if you are perhaps a good." You can draw things or something. You can also use that. So use your imagination to yeah, make your own yeah, pictures and also use them yeah, to get free copyright for yourself for your own website. And of course, if other people are using your pictures without authorization, you can find them. So that's also fun. Yeah, or other esteemed speaker already talked about it, but there's also, of course, the possibility of using old illustrations and photos. And yeah, you have the 70 years rule, 70 years after creator passed away, you can use yeah, their content for free. So perhaps if you want to write about the riots in Paris, the recent riots, and you don't have a good picture on YouTube, or and you don't have the money to use photos of Reuters or Associated Press, you can perhaps yeah, use that very famous picture of Liberté que dans le peuple of the late French painter Delacroix, because yeah, he made it very famous painting in 1830, and he died in 1863. Yeah, search on Wikipedia, of course. So you are yeah, totally free to use that image because yeah, he is not there. Or if you are writing an article about Java, you don't or Jakarta, and you don't have a good picture of the town, you can also use an historical picture like that one. And of course, I mentioned the source. It is the widow of Jacob van Meurs, and this the new gate in Batavia, now Jakarta, in the Royal Library in The Hague. So it's all for free now. Now, next slide, please. Yeah, we can if you want to. I don't know if there's access there to press on the hyperlink, because if that is possible, I can we can give an example of how I do that with a certain article. Can you access the internet from there with the hyperlink? Then you have to one slide back. Yeah, one slide back, please. Back. Excuse me. Back. Yes, one back, please. The one before. Yes, you can click on that one. Yes. Yes, it's yes. Oh, and you press on accord. Yes. You can slide down. Now that's a photo. It's copyright free. It was made in 1921, and I'm sure the photographer is gone. Also, this photo was published on Wikipedia, and it is rights free for an article about reparations for survivors of the Tulsa race massacre in 1921. The survivors now are in above 100 years old. And yeah, it was not. Yeah, we of course we don't use photos of Associated Press or New York Times of the court proceedings now, but we use historical pictures because that is rights free. Now you see also oh, it's from Pickerel. Now, but it is rights free. Oh, you can prove a little lower. Oh yeah, that's me. It's not copyright free, that picture. Sorry. Slide down, please. Down. Yes, that one is a screenshot of YouTube of the lady who is still alive and was a witness of that massacre. She's 113 years old, I think. You can slide down. And there is also a Wikipedia. Down. Yeah, that one. You see, that's a Wikipedia picture of a museum, and also we wanted to give the credits to not only to the maker of that picture. It is a pseudonym, but also give a link. So we do that with a hyperlink. Therefore, the name of the one, the pseudonym of the person who made the picture is read. So then you are completely sure that there will be no complaints about the using of your copyrights. So thank you. You can now go back to the PowerPoint presentation again. Oh, and then we have to go see it all again. Yes. Next. Yes, here. Yeah. Now, another topic that is about, yeah, for journalists is important is play. I hope I pronounce it right. I'm not as good as English as native speakers. Plagiarism, yeah, in Dutch, plagiaat. Now, sometimes, yeah, I've witnessed it sometimes that other websites are copying, but literally copy paste articles of mine or of my colleagues without consent. And sometimes they name the source. It's posted in the kanttekening, but they post a whole article. Now, we always send those websites. Most times there are very minor websites, and they're also not commercial. An email with the request, of course, to remove the content. Or, and sometimes we do that, post a part of it, just the first two alineas, and then give a link to our website. So people who want to read further, they can click on the link and they will go to our website, and then we have more clicks. And that's always important for online journalism. Now, we never had to take legal action. Now, one time I was thinking to do that, but I decided not to because that cost a lot of time, and I don't know what the legal consequences are. And also, my fiancée Farah, she's up there. Can wave. Told me that it was on a Balinese news website. They have translated an article I wrote. It was also about Indonesia, and yeah, it was not written by me, but written by somebody else. She was the person was too lazy to write her own article, but yeah, just use the Google Translate or L, and then post it without my consent, but also without her own IDs. It was the same article, so that is so I think I've written a protest, but I never got an email back. But I was thinking, it's not of very big importance for me. If it was a Dutch website, or perhaps from Belgium or something, I will take legal action. But this time I was thinking it's not. It will take a lot of effort and time to do this. So I let it pass away. Now, in the Netherlands, cases with plagiarism and journalism, they are very rare, and those cases who are they are very they got a lot of attention also from the news. Now I have two cases are very recent or and infamous. The first is about Geerlof de Mooi. He's now 27, and he returned back to journalism after 7 years of exile out of journalism. In 2015, he was expelled as an intern from the Volkskrant. That's one of the biggest newspapers in the Netherlands. After the Volkskrant discovered he was guilty of plagiarism. He copied a lot of articles from foreign websites, and also from some local Dutch news websites, and he just copy pastes text, and he did acknowledge that he was using their sources, but he was pretending that it was those things were his own findings, and after they discovered that he was doing that, they expelled him out of the intern program. So that was very bad for his journalistic career. Now, for his defense, he felt a big pressure to perform, to make a lot of articles, and also it was I think because he was just 19, gullibility. And also youth, because he was very young. And but now he's got a second chance, not by Volkskrant, but by Noord-Hollands Dagblad, the North Holland Daily. So now I hope he will never sin again. Also, I mean in the journalistic sense. Now the other one that was more severe was Peter Blesik or Blasik. He's not really a journalist, but he is he works as an official for local government in Roermond, and he also is writing journalist articles. But 27 articles were revoked by magazine HP De Tijd because he committed plagiarism, but also he used a lot of very fable, I pronounce it rightly, sources. So a lot of people he named in his articles, it's not clear that those people exist at all, or that he made it all up, and that is of course a bigger sin than not giving credits to other journalists because yeah, if you are making things up and people don't discover that, then you are making fake news. Now that is I think also the biggest journalist sin, the fake news thing. Now, one of the most infamous cases that is Perdi Bramazar, Hindu Suriname Dutch journalist, now a former journalist, luckily. And yeah, he was very famous and also very renowned because of his articles and his interviews, and it was very well written, but it was more fiction than reality. He also made up the so-called Sharia triangle. He said, yeah, there is a place in the Schilderswijk in The Hague. In The Hague, there live a lot of Muslim people, especially from Morocco, and they are not integrated in Dutch society, he said, and they also yeah, wanted to impose Sharia law, so he called it the Sharia Triangle. It sounds very like Bermuda Triangle. It's very bad. And yeah, in a literary sense, perhaps he yeah, as a writer of fiction, that is of course a smart invention. But as a journalist, you are also like historians and others. Yeah, committed to the truth. So it was a big sin. And now, thanks to an acquaintance of mine, I think, but I'm not sure, they discovered that he was a fraud because was a Dutch artist, or he's still Le Boer. He invented a couple of years ago, 2016, Nizar Mourabit. That was a major Moroccan person, and yeah, we call it in Netherlands opinie Marokkaan, opinion Moroccan. And now, first, Nizar wrote an article on the left-wing website Joop. Joop is part of VARA. VARA is a Dutch broadcast station. And Joop didn't check his background. Now, Nizar Mourabit does not exist, and his photo, it is a little bit a Photoshop of an existing Arab sheikh. So they never checked it. And then, because he was on Joop, he also appeared in Parool. They were thinking, who is Nizar Mourabit? Oh, he is written on Joop, so that is an existing person. And then he also was in the Volkskrant, so yeah, the most renowned newspaper in the Netherlands. So he yeah, pranked them all. And then yeah, one Dutch news outlet, The Correspondent, they were a little bit critical because yeah, Nizar Mourabit, he was on Facebook, on Instagram, on LinkedIn. Nelle did it all, of course, to check him, but yeah, he was of course difficult to reach. I think Nelle has a burner phone, but nobody calls him because he cannot speak with a Moroccan accent. So Karel Spouter was suspicious, and then yeah, after what happened to Volkskrant, and there were a lot of media requests because they wanted to have Nizar Mourabit on television because he made some interesting articles. The broadcast programs found. Nelle Boer decided to tell Karel Smouter the whole story. So yeah, that it was all made up, and that because he was critical, he kept his yeah, he had the right to write that story. And then yeah, it was all going crazy in the media, and for 2 weeks they were calling about Nizar Mourabit, the Arab man whose picture was stolen, was very angry at Nelle Boer because his copyright was, of course, not respected. But yeah, because it was all for art, Nelle said, yeah, this was on purpose. Oh, 5 minutes, yeah. Okay. So it can be very interesting. Oh yeah, my last slides. Yeah, next one. That's about the code of conduct for journalists in the Netherlands. Now, there is a code, and of course, it's not a law, but yeah, if you want to be a good journalist, you have to yeah, listen to a certain set of rules. No plagiarism, of course, but also name sources, not just hyping. That is also a way you can plagiarize in a more sophisticated way, that you post a link, but then you pretend that it's your own story, but you are really copy pasted from another website, but you give the link, so it's not officially plagiarism, but according to the code of conduct for journalists, that is not, not the way you should act as a journalist. Now, I have also a personal code as a journalist. Original. Oh yeah, there's one letter is missing. Call other experts or witnesses for original content. So if you have some news and you want to have, you don't want to retell it, then you can call an expert who can, tell something about that issue, and you have original content. You can rearrange the story if you don't have the time, focus on another aspect. And now there are a lot of guidelines for it. You can find it on the link. The most important, however, no fake news, a fair hearing. Don't create news yourself by creating commotion. You can say, "Oh, there's a fire," but you light the fire yourself. That's no news, of course, and also it's not good. Now, protect your sources if that's necessary. Very important. You can sometimes anonymity is very important, and check and double check, of course. One source is no source. There is one person is telling you something, and that's the only one. You should be very skeptical. And very important, admit and correct your own mistakes, and also no false balance. That if you are talking, let's say, about the COVID pandemic, and you have on the one, you have an article, you have two experts. One is the real expert, and the other one is a conspiracy theorist. They are no equal persons, of course. So that's a false balance. You shouldn't do that. Or one Holocaust denier and one normal historian. So that is not the way you act as a journalist. Now, conclusions. I will do it a little bit fast. Now, be very careful when using pictures and photos, because you don't want a fine. Ask always for permission as a solution to photographers. Check and double check photos, especially when it's from Wikipedia. And also be creative. You can make your own photos or use YouTube, etc. Now, plagiarism is a problem too. And it's a rare phenomena in the Netherlands, but I think also in other countries, because it destroys your reputation. If I commit plagiarism, I destroy my career as a journalist. And of course, it's not good, but also I'm keen on my career, so I don't do it. Now, an important solution is to counter plagiarism is notify them if people are plagiarizing your articles. And as a writer, also again, be creative, write your own stories, and also be very careful about Jet GPT. I told you of an assistant professor. I don't see him here in the room, but I was talking before this conference started with an associate professor here, and we're also talking about the problem of Jet GPT. And in the Netherlands, there is a new party, the BBB, the Farmers Party, and they don't have time to write their political program. There will be elections in the Netherlands in November, so they use Jet GPT to write their program. That's crazy, but this, of course, we should course be very also as academics, I think, be mindful that will not be our future. So I think when it's about copyright, creativity is, I think, the solution. Thank you very much.
Okay, thank you, Dr. Ewart Clay. Okay, from his explanation, I noted several important points. The first is be careful with so many digital sources like Facebook, Twitter, etc., including Wikipedia, because not always copyrights free. And then also solution to avoid fines for photo. Please make sure the materials that you use is copyright material free. And also, there are a code of conduct for journalism, like no fake news, fair hearing, don't create news yourself by creating commotion, and also always protect your sources. Okay, all of the participants, now we move to our next speaker, will be Professor Budi Agus Riswandi. I will briefly read his curriculum vitae. Professor Budi Agus Riswandi, Professor in Faculty of Law, Universitas Islam Indonesia, and also Dean of Faculty of Law, Fakultas Hukum, Universitas Islam Indonesia. Professor Budi has so many publications. I noted there are 18 books and more than 50 articles. Okay, without any further ado, Prof. Budi, you have 20 minutes to deliver your works. The time is yours, Prof. Yeah.
Thank you very much, Ms. Indah Rahadian as moderator. And first, thank you very much to Dr. Nadia and Dr. Iwad because you can sharing today about copyright and journalism. And I hope my student can got many information because the perspective is very, very different between Indonesian and Netherlands and UK. So today I will presentation about right of publisher in Indonesia copyright and related right system toward qualified journalism. But I have a request to Mr. Indah Rahadian. Please allow me a presentation in Bahasa because I think it will more easy and interactive with audience. So my student, I think is okay to presentation in Bahasa. But if Nadia and Dr. Watt want to know what I say, maybe Miss Indah will be give information. Thank you very much. Saudara sekalian, tema kita hari ini mengenai hak cipta dan jurnalistik gitu ya. Ini tema yang sangat menarik dan di Indonesia ini menjadi isu yang sangat hangat sebenarnya karena beberapa saat yang lalu Dewan Pers itu sudah mengusulkan kepada Presiden untuk membentuk peraturan Presiden, mengesahkan peraturan Presiden mengenai hak publisher ini atau publisher right gitu ya. Nah, barangkali yang menjadi pertanyaan, kenapa Dewan Pers itu menawarkan atau mengusulkan kepada Presiden Republik Indonesia untuk mengesahkan peraturan Presiden mengenai publisher right ini. Nah, perlu diketahui oleh saudara semua bahwa perkembangan teknologi informasi hari ini berkembang sangat pesat dan sangat kompleks. Dan tadi Pak Rektor sudah menyampaikan ada dua sisi dari perkembangan teknologi, sisi positif dan sisi negatif gitu ya. Nah, sisi negatif kalau dikaitkan dengan perkembangan teknologi informasi hari ini rupanya berdampak kepada perkembangan industri atau perusahaan pers di Indonesia, di mana kita tahu pers sekarang tidak hanya dikembangkan dengan model offline, tetapi juga memanfaatkan platform digital atau kita kenal dengan model online. Nah, ternyata dengan diterapkannya model jurnalistik berbasis kepada platform digital ini, tidak serta-merta itu menguntungkan bagi kepentingan perusahaan pers nasional. Tetapi ini justru sebaliknya, dianggap merugikan kepada perusahaan pers nasional. Kenapa demikian? Karena ternyata hadir platform digital yang itu menjadi agregator digital dari konten-konten yang disajikan oleh perusahaan pers nasional. Dan itu dimonetisasi, diambil keuntungan ekonominya oleh platform-platform digital yang besar ini. Misalnya kita tahu ada Google News. Ya, Google News itu kalau saudara cek itu sekarang, itu menampilkan konten-konten dari perusahaan pers nasional. Memang untuk akses ke situ tidak berbayar. Tetapi saudara harus tahu bahwa tidak berbayarnya itu tidak berarti itu gratis. Karena di situ perusahaan Google itu memperoleh manfaat ekonomi dengan memberikan kesempatan perusahaan-perusahaan iklan mendisplay iklannya di situ. Jadi sekarang perusahaan iklan itu daripada mendisplay iklannya di perusahaan-perusahaan pers nasional, lebih baik mereka mengiklan di platform-platform digital besar tadi. Di Google News, di Facebook, Twitter, dan lain sebagainya. Nah, tentu ini akan menjadi masalah, ya. Akan menjadi masalah bagi pertama keberlanjutan perusahaan pers itu sendiri. Dan yang kedua, ini akan berdampak juga kepada pers yang berkualitas. Nah, oleh karena itu, saya coba hari ini menjelaskan masalah ini dari sisi hak cipta dan hak terkait, ya. Jadi di sini kita isunya tidak hanya soal hak cipta, tapi hak terkait. Tadi Dr. Nadia sudah memberikan pengantar. Sebenarnya konsep dasarnya tidak terlalu jauh beda apa yang ada di UK maupun di Indonesia. Karena kita punya standar yang sama berkaitan bagaimana memformulasikan ketentuan undang-undang hak cipta kita secara nasional. Yang itu merujuk kepada konvensi-konvensi internasional. Kita tahu ada konvensi Bern, kita tahu ada namanya WIPO Internet Treaties, dan itu semua sudah kita ratifikasi, dan itu semua sudah kita adopsi ke dalam sistem hukum hak cipta nasional kita. Nah, kalau kita bicara hak cipta, saya ingin menambahkan, dan ini sering saya sampaikan di dalam kelas, bahwa ketika kita kita bicara hak cipta, kita tidak hanya berbicara tentang hak eksklusif. Itu yang harus Anda tahu. Kita tidak hanya berbicara soal hak eksklusif. Terus, Mas Wan? Tetapi kita juga harus bicara soal fleksibilitas yang ada di dalam hak cipta itu sendiri. Kalau bagi kita negara berkembang ini penting. Saya selalu katakan ini penting, memahami konsep hak cipta sebagai hak eksklusif, tetapi dalam konteks hak cipta juga ada fleksibilitinya, ada kelonggarannya. Ya, lanjut Mas, lanjut. Terus, nah, kalau saudara membaca Undang-Undang Hak Cipta kita nomor 28 2014, ini sebenarnya cukup banyak konten yang berbicara tentang hak eksklusif dan konten berbicara mengenai fleksibilitas. Aturan yang berbicara mengenai hak eksklusif dan aturan yang berbicara mengenai fleksibilitas. Itu semua diakomodir di dalam undang-undang hak cipta kita. Contoh, hak eksklusif itu kita mengenal ada hak moral. Kita mengenal ada hak ekonomi. Kita mengenal ada hak mengalihkan. Kita mengenal ada hak melarang. Itu adalah sisi hak eksklusif dari hak cipta. Tapi di sisi lain ada juga kelonggarannya. Kelonggaran ini apa sih yang boleh dilakukan terhadap sebuah konten yang dilindungi hak cipta dan itu tidak melanggar undang-undang hak cipta. Nah, ini ada yang namanya pembatasan perlindungan, ada yang namanya doktrin fair use atau fair dealing, ada juga namanya non-copyright. Contohnya saudara mengutip peraturan perundang-undangan, putusan pengadilan, nggak perlu itu pakai catatan kaki, karena itu tidak ada hak ciptanya. Kemudian juga ada namanya compulsory license, lisensi wajib. Nah, sekali lagi, ini kenapa diformulasikan undang-undang hak cipta kita seperti ini? Karena kita ini negara berkembang, membutuhkan kedua-duanya. Di satu sisi, kita membutuhkan dorongan terhadap para kreator menghasilkan ciptaan yang bisa dilindungi hak cipta, dan itu perlu dihargai, perlu dihormati, perlu dilindungi. Tetapi di sisi lain, kita juga membutuhkan akses informasi, akses terhadap ciptaan yang dilindungi hak cipta, namun jangan sampai itu dikriminalisasikan. Itu dianggap melanggar hak cipta. Maka koridornya ada di aspek flexibility ini, kelonggaran ini. Lanjut. Nah, saudara, kalau kita bicara hak cipta, hari ini kita ada di dua dunia. Kadang kita bicara di dunia nyata mengenai hak cipta, tapi kadang kita bicara mengenai hak cipta di dunia maya. Nah, kalau pertanyaannya, apakah undang-undang hak cipta kita itu berlaku untuk aktivitas-aktivitas di dunia maya? Berlaku. Apalagi undang-undang hak cipta kita itu sudah mengakomodir yang namanya WIPO Internet Treaties, WIPO Copyright Treaty, dan WIPO Performance and Phonogram Treaty. Ini sebenarnya semuanya bicara tentang hak cipta di dunia maya, atau kita katakan hak cipta digital. Nah, sistem hak cipta digital di dalam hukum kita, kalau saya baca, itu ada 3 aspek di situ yang diatur. Ada aspek mengenai hak cipta digital, artinya karya-karya digital itu sebagai hak cipta digital yang itu dilindungi oleh undang-undang hak cipta. Contoh, karya tulis, gambar, musik, film, semua diformat dalam bentuk digital itu dilindungi oleh hak cipta. Ya. Kemudian bicara digital copyright system juga di dalamnya mengakomodir aspek teknologi untuk melindungi hak cipta. Ini ada 2. Maaf, ada 3. Ada yang namanya manajemen informasi hak cipta, dan ada namanya informasi elektronik hak cipta. Nah, ini apa yang dimaksud? Ini adalah sarana teknologi yang diharapkan bisa melindungi hak cipta, bukan sekedar dilekatkan, tetapi itu bagian dari proteksi hak cipta. Itu ya. Dan yang terakhir, bicara sistem hak cipta digital di Indonesia, ini kita mengenal adanya pengawasan yang dilakukan oleh pemerintah sebagai pihak yang diberikan otoritas. Nah, ini 3 hal yang harus diketahui di dalam sistem hak cipta digital. Next. Saya coba sekarang uraikan tadi mengenai digital copyright. Jadi sebenarnya yang dilindungi oleh hak cipta itu ya semua kreasi. Mau diumumkan, tidak diumumkan, tadi Nadia bilang fiksasi, originality, kreatif, itu menjadi persyaratan. Sebuah ciptaan bisa dilindungi hak cipta. Soal formatnya itu fisik atau digital, itu sama. Gitu ya. Kalau dulu kita kan musik lagu itu di format dalam bentuk kaset, dalam bentuk CD, itu kan fisik. Kalau sekarang kan formatnya sudah MP3, MP4, dan lain sebagainya. Itu digital. Dan itu termasuk objek yang dilindungi hak cipta. Itulah yang dimaksud dengan digital copyright. Lanjut. Nah, kemudian aturan mengenai copyright management information dan electronic copyright information ini juga sudah diakomodir dalam undang-undang hak cipta kita. Di dalam pasal 7 undang-undang hak cipta kita itu ada penjelasannya. Apa yang dimaksud dengan copyright management information itu mencakup informasi mengenai metode atau sistem yang dapat mengidentifikasi orisinalitas dari substansi ciptaan yang dihasilkan oleh penciptanya. Di sini juga bisa berupa informasi kode atau akses kode. Kita kan sering ya kalau mau buka elektronik jurnal, mau tidak mau kita harus punya password. Nah, password itu untuk membuka konten tadi supaya punya hak akses, dan itu bagian dari copyright management information. Oke, next. Kemudian ini ada yang namanya kalau di kita dikenal dengan istilah sarana kontrol teknologi, ya. Sarana kontrol teknologi juga bagian dari ketentuan hak cipta yang mencoba merespon perkembangan hak cipta di dunia digital. Di sini dikatakan setiap orang tidak boleh merusak, menghilangkan, membuat alat kontrol teknologi yang itu tujuannya melindungi teknologi, tidak boleh. Dan itu kalau terjadi bisa menimbulkan pelanggaran hak cipta. Jadi sekarang kita isu bicara hak ciptanya bukan lagi kreasi yang berkaitan dengan bidang seni, sastra, ilmu pengetahuan, tapi hak cipta juga sudah masuk ke wilayah teknologi. Kan itu, karena teknologi ini punya fungsi. Ternyata undang-undang hak cipta sekarang melindungi juga teknologi. Jadi ini sedang ada perkembangan. Ya, salah satu buktinya di undang-undang hak cipta kita kalau dikatakan hak cipta itu melindungi karya seni, sastra, dan ilmu pengetahuan tidak sepenuhnya benar. Tetapi juga melindungi aspek teknologi. Padahal kalau kita belajar tentang intellectual property right, kita bicara perlindungan teknologi, itu wilayahnya wilayah paten. Bukan wilayah hak cipta. Tapi sekarang itu sudah masuk ke wilayah hak cipta. Artinya apa? Inilah dampak dari perkembangan ilmu pengetahuan dan teknologi yang berpengaruh kepada aturan-aturan di bidang hak kekayaan intelektual. Lanjut. Nah, kemudian ini pengawasan. Sekali lagi, pemerintah di Indonesia itu diberi hak untuk mengawasi. Dalam hal ini mengawasi pembuatan, pendistribusian konten yang melanggar hak cipta, maka ini harus diawasi oleh pemerintah. Jadi bukan hanya konten berupa hoax, konten yang berupa hate speech, dan lain sebagainya yang itu harus diawasi oleh pemerintah, tetapi konten-konten yang dianggap melanggar hak cipta, ini juga harus diawasi oleh pemerintah. Siapa pemerintah itu? Pemerintah itu adalah Menteri Hukum dan HAM. Dalam hal ini diberikan kepada Direktorat Jenderal Kekayaan Intelektual. Dia harus mengambil tindakan di pasal 55 itu, tentunya dengan keputusan menteri, karena menteri yang diberi kewenangan, ini menutup, memblokir konten-konten yang dianggap melanggar hak cipta. Meskipun ini bicara efektivitasnya, ya bisa kita ketahui ya. 5 yang diblokir, 100 yang muncul yang baru, kan kira-kira gitu ya. Ya inilah dunia maya kita, memang cukup melelahkan. Ya, cukup melelahkan. Nah, tapi ingat, ketika pemerintah memblokir, itu dalam waktu 14 hari, 14 days itu, maka harus ada penetapan dari pengadilan. Kalau tidak, ini bisa dipersoalkan putusan menterinya itu, gitu ya. Nah, ini kaitannya dengan hak cipta di medium digital, di mana pemerintah punya hak pengawasan. Lanjut. Nah, kita masuk sekarang ke dunia pers, jurnalistik. Ya. Undang-undang pers kita itu menyatakan bahwa pers nasional itu punya peranan. Nah, ini peranannya ini ABCDE itu ya. Itu ada the people right to know, ada the fundamental value of democracy, ada develop public opinion, kemudian ada supervision, criticism, correction and advice to public interest, ya, kemudian justice and truth. Ini peran yang harus dimainkan oleh pers, oleh jurnalistik kita, ya, berdasarkan undang-undang pers kita. Lanjut. Kalau membaca undang-undang pers kita, itu ada 2 aktor penting di situ yang diatur, sekaligus mengatur kepentingannya. 2 aktor itu siapa? Jurnalis sama perusahaan pers. Ya, Nah, jurnalis itu kepentingannya mereka itu adalah mendapatkan perlindungan hukum. Itu ya. Sementara perusahaan pers itu bagaimana dia bisa menyediakan kesejahteraan bagi para jurnalis. Nah, kenapa kita berangkat ke sini? Karena nanti kita akan bahas soal fenomena yang terjadi di medium digital tadi, gitu ya. Jadi sebenarnya wartawan itu berhak untuk dilindungi dan punya kepentingan untuk dilindungi oleh hukum. Dan yang kedua adalah perusahaan pers juga punya tanggung jawab, punya kepentingan. Bagaimana wartawan-wartawannya ini hidup sejahtera, kira-kira gitu. Jurnalisnya ini hidup sejahtera. Dan itu sudah ditentukan di dalam undang-undang pers kita. Lanjut. Nah, sekarang kita bicara kondisi existing dari jurnalistik kita, pers kita hari ini. Itu salah nulisnya ya, mohon maaf. Yang atas, jurnalis, press company, society, itu adalah proses bisnis yang terjadi sebelum teknologi informasi seperti hari ini. Jadi dulu kalau KR itu mau membuat berita, wartawannya mencari berita, beritanya dibuat, dikirim KR, KR langsung dikirim kepada masyarakat. Sudah, masyarakat bisa menikmati berita. Hari ini itu tidak demikian. Dan waktu perusahaan Press KR itu sudah menerima iklan-iklan yang banyak. Itu ya. Itu yang dulu. Yang sekarang nggak begitu. Yang sekarang jurnalis, press company ada digital news aggregator. Ini yang meraup iklan yang banyak. Ya, sementara jurnalisnya nggak dapat apa-apa. Kenapa nggak dapat apa-apa? Karena perusahaan persnya sendiri juga nggak dapat apa-apa, kira-kira gitu. Makanya kalau kita lihat KR itu sekarang mungkin pelan-pelan nanti lama-lama hilang itu. Tinggal sejarah aja, tinggal cerita saja. Dan beberapa media mainstream yang ada di kota Jogja ini, banyak ini yang sudah pada berguguran. Contoh misalnya kita ada dulu ada Bernas. Bernas masih ya sekarang, tapi makin ke pinggir sekarang. Bukan ditanya yang makin ke pinggir, tapi kantornya makin ke pinggir karena nggak mampu lagi membayar sewa dan lain sebagainya. Itu ya. Nah, baru ke masyarakat. Anda sekarang kalau cari berita kan daripada nyari ke platform digital perusahaan pers nasional, mendingan cari di Google kan? Karena di Google itu ada semua di situ. Tinggal Anda buka itu. Gitu ya. Nah, dengan adanya perkembangan seperti hari ini, lalu apa isunya yang muncul? Lanjut. Isunya yang muncul, pertama ini ke jurnalisnya, ke wartawannya. Wartawan itu sebenarnya punya hak cipta. Ya. Tetapi jangan salah, walaupun wartawan itu punya hak cipta, ini agak berbeda di negara-negara common law. Kalau di negara-negara common law, hak cipta itu milik publisher. Kalau di kita enggak, hak cipta itu milik autor, jurnalis. Itu yang punya hak cipta. Kalau Mbak Farah kerja di hukum online, ada wartawannya tidak tiba-tiba itu kontennya milik, hak ciptanya milik hukum online, nggak bisa. Kecuali di perjanjian lain. Nah, ini harus ada agreement. Gitu ya. Cuma nanti, kalau itu kan ada hak ciptanya, kalau itu nanti dipakai oleh orang lain, digunakan, dikutip oleh orang lain, ada peluang terjadi pelanggaran hak cipta. Tetapi di pasal 43 Undang-Undang Hak Cipta, sebenarnya ngutip berita itu boleh, saudara. Tidak salah. Dan tidak melanggar hak cipta. Selama disebutkan sumbernya. Artinya tidak melanggar hak daripada si wartawan tadi. Kira-kira gitu ya. Nah, kemudian ini dalam rangka mengembangkan jurnalistik yang berkualitas, hari ini nggak bisa. Wartawan independen itu nggak bisa. Uang perusahaan pers saja sekarang mau collab kan kira-kira gitu. Itu yang sudah diorganisir dengan baik. Apalagi wartawannya sendirian, nggak bisa. Posisi tawarnya lemah sekali. Maka menurut saya, karena Undang-Undang Hak Cipta itu mengatakan hak cipta karya pers itu milik jurnalisnya, maka mestinya ini ada kesepakatan antara jurnalis dengan perusahaan persnya. Misalnya tadi hukum online ya buat perjanjian diserahkan kepada perusahaan persnya, dan itu tujuannya adalah dikelola supaya bisa memberikan dampak positif kepada kepentingan si wartawan sebagai pencari berita. Itu ya. Jadi isunya mengenai hak cipta dari jurnalis. Ini perlu ada konsensus dengan perusahaan pers supaya bagaimana hak cipta dia itu bisa dikelola. Meskipun pertanyaannya apakah nanti perusahaan pers ini bentuk kerjasamanya apa perjanjian atau peraturan, itu nanti diskusi yang lain lagi. Lanjut, isu lain dari hak cipta ini kepada perusahaan persnya. Tadi dikatakan gambaran sekarang ini. Jadi sekarang akses kontrol dan akses kopinya itu ada di platform besar, namanya digital news aggregator. Dan di situ digital news aggregator juga mendapatkan keuntungan ekonomi. Dua keuntungan yang dihasilkan oleh digital news aggregator itu sekaligus itu masalah bagi perusahaan pers nasional maupun wartawannya atau jurnalisnya. Nah, cuma di sini perusahaan pers sendiri juga punya problem. Problemnya apa? Dia tidak punya tata kelola hak cipta yang baik terhadap karya-karya jurnalis. Ya, nanti bisa diskusi dengan Mbak Farah itu. Tata kelolanya akan seperti apa? Ya, bagaimana memanage copyright sebagai sebuah aset yang ini diharapkan bisa mensejahterakan kepada wartawannya. Yang kedua, ada kelemahan dari perusahaan pers nasional kita ketika berhadapan-hadapan dengan digital news aggregator. Nggak usah ngomongin royalti dengan mereka. Negara mau minta pajak aja kepada Google tuh susahnya minta ampun. Negara ini. Padahal negara itu kan lebih gede daripada perusahaan pers. Apalagi perusahaan pers mau minta royalti ke Google, dicuekin aja bisa terjadi, saudara. Posisi tawarnya lemah. Nah, dalam rangka menjawab dua isu tadi, di Indonesia sebenarnya sekarang Dewan Pers mencoba mengusulkan tadi kepada pemerintah untuk membuat peraturan presiden ya mengenai publisher right. Tapi ini tidak semua wartawan, tidak semua perusahaan pers juga setuju. Karena dianggapnya ini sebagai hal yang akan merontokkan perusahaan-perusahaan pers baru. Yang notabene-nya nanti dalam membuat konten berita, mohon maaf ya, itu banyak merefer kepada perusahaan pers yang lama. Misalnya berita antara dikutip lagi oleh media, dikutip lagi, kira-kira gitu. Nah, kalau perusahaannya kerjaannya bukan bikin berita, tapi ngutip berita, ini kan bisa kena ini oleh aturan tadi. Nah, itu isunya. Dan isu yang lain, peraturan itu dianggap akan berbenturan dengan undang-undang hak cipta. Dan saya setuju itu. Sebenarnya pemerintah kalau mau ngatur soal dampak buruk dari perkembangan teknologi informasi terhadap pers kita, lebih baik memperkuat undang-undang hak cipta. Ya, undang-undang hak cipta. Bagaimana cara memperkuatnya? Di analog aja seperti halnya lembaga penyiaran. Sekarang lembaga penyiaran sudah kuat. Jadi itu konten-konten televisi, Indosiar, SCTP, RCTI di display di YouTube, itu YouTube mau tidak mau harus bayar dengan lembaga penyiarannya. Bukan hanya kepada pemegang hak ciptanya. Makanya kan TV.net, SCTP segala macam berlomba-lomba masuk di YouTube. Karena dia dapat benefit dari situ. Dan YouTube tidak boleh tidak memberikan hak ekonomi kepada lembaga penyiaran tadi. Ya. Nah, cuma kalau memang itu mau dimasukkan ke undang-undang hak cipta, kelebihannya sebenarnya satu. Ini bentuknya undang-undang, lebih kuat. Partisipasi masyarakat akan lebih banyak. Masukan akan lebih banyak. Isi dari materi undang-undang akan lebih detail. Artinya detail itu aturannya tidak dibuat sesederhana yang sekarang ini dibuat oleh Dewan Pers. Karena saya baca draftnya itu dari Dewan Pers itu terlalu sederhana. Padahal ini ada hal-hal yang kapan konten berita ini boleh digunakan dan tidak melanggar dalam rangka kebebasan pers, dalam rangka melakukan upaya mencerdaskan bangsa, dan kapan konten itu harus berbayar. Ini harus diatur dengan baik. Dan aturannya itu menurut saya lewat undang-undang hak cipta. Barangkali itu yang bisa saya sampaikan. Semoga bermanfaat. Hanya sebagai pemantik. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Prof. Budi. Ladies and gentlemen, based on Prof. Budi presentation, I noted some points. First is that talking about copyrights, it's not only talking about exclusive rights, but also about flexibility in copyrights. And also, Prof. Budi mentioned that digital copyright system in Indonesia accommodates so many like digital copyrights, copyrights management information, copyrights electronic information, and technological control tools. And also, there are many issues against the company, like the press company doesn't have good management over it. And second, a weakness in a press company bargaining position in front of the digital news aggregator, like, for example, Google. Okay, operator, move to our next speaker is Prof. Peter Mezi joining us or not yet? Belum. Okay. Okay, because Prof. Peter hasn't joining us yet, so we move to our first round question and answer session. I invite two participants. Okay, Mas, one more. Yeah, Masnya. First, mention your name, institution, and to whom you will address your questions, please. Okay. Yeah.
Yes. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone, doctors and professor. My name is Rizky Nur Iksan from International Relation Department. So I believe that intellectual property right was introduced by the US President Alexander Hamilton to protect the US infant industry in 19th century. And the form of intellectual property was used as an instrument to get the US national interest on that era, and copyrights is one form of intellectual property. So the question is digital transformation era, in the digital transformation era, it is possible to copyright and journalism are used as an instrument to limit other countries. Thank you.
Okay. I think that every speakers could give a comment or answer from the perspective of your country, or is it from perspective of Netherlands and also UK, or only the United States perspective, Mas?
It can be from every perspective.
Okay, okay. Please, Nadia, could you give comments from her, his questions? Yeah. Oke, oke. Ulang lagi intinya. Ya.
Oh, okay.
Oke.
The main point is in the digital transformation era, it is possible to copyright and journalism field are used as an instrument to limit other countries.
Thank you. So IP rights legally are territorial. So you have your right, for example, in the United Kingdom, and then for another country, you have to register it in the other country. So if you have IP rights in the United States, then outside of the United States, you need to register them to be able to enforce them. For example, if you're thinking about the EU, there's copyright exhaustion. So once it is in the EU, you have an exhaustion of rights. So that has an impact on it. And then with the digital era, you're right. It makes it very, very complicated because it's being streamed, it's being shared at a mass level. So how do you control that? So the legislation helps, the drafting of the policies help. WIPO, the World Intellectual Property Office, play a great role in this, and they look at
IPO, artificial intelligence, intellectual property and frontier technologies, and that's where they're tackling the impact of it. But it's not, there's no one answer to it, but it is something that's in development at the moment and definitely worth following and seeing how it's going.
I think it's a subject a little bit too complicated for me as a journalist. So perhaps if other people later have questions for me more about journalism or more yeah, the simple questions I can, but this is all off my head. I'm very sorry.
Baik, thank you. Terima kasih. Saya jawab ya. Jadi perlu diketahui bahwa sistem hukum hak cipta kita itu menganut prinsip territorial system. Artinya hukum nasional Indonesia hak ciptanya ya berlaku di Indonesia, tapi tidak berlaku di negara lain. Kira-kira gitu ya. Sehingga kalau ada perbedaan-perbedaan antara United Kingdom with Indonesia, itu tentu perlu ada kerjasama bilateral di antara keduanya untuk membatasi itu, menyelesaikan itu. Nah, ini yang menarik. Teknologi informasi itu punya karakteristik a-jurisdiction, multi-jurisdiction. Maka hukum yang dikembangkan sebenarnya tidak bisa territorial system, tapi harusnya extraterritorial system. Nah, bagaimana copyright menjawab perkembangan teknologi informasi ini? Maka mestinya WIPO sebagai organisasi yang mengadministrasikan soal konvensi-konvensi yang berkaitan dengan intellectual property right itu mulai menginisiasi bagaimana terbentuknya copyright system di dunia ini yang lebih universal, lebih seragam. Kira-kira seperti itu. Nah, sekarang yang terjadi contohnya di Undang-Undang Perlindungan Data Pribadi. Undang-Undang Perlindungan Data Pribadi itu pasal 2-nya bicara extraterritorial system. Jangan salah, kontennya itu banyak mengkopi dari Uni Eropa. GDPR. Ya. Itu jadikan model, tapi jadikan model kalau sudah disahkan itu menjadi hukum positif kita. Nah, makanya ini perlu dengan perkembangan teknologi informasi ini, saya kira para expert itu berdiskusi di WIPO untuk mengembangkan aturan-aturan hak cipta ini bisa lebih fleksibel lagi dengan perkembangan-perkembangan yang ada. Tetapi sekali lagi, ini ada perbedaan perspektif antara negara maju dan negara berkembang. Dalam merumuskan konvensi itu juga tidak mudah. Kenapa? Karena negara maju lebih senang kalau copyright itu kuat, sisi hak eksklusif. Kalau negara berkembang, maunya kan lebih longgar. Karena ini sedang transformasi ilmu dan pengetahuan, kan kira-kira gitu ya. Nah, nanti kalau itu sudah ketemu di forum internasional, itu diskusinya panjang. Dan kita ingat, waktu TRIPS Agreement itu mau masuk ke WTO, itu terjadi tarik-menarik antara negara maju dan berkembang. Negara berkembang nggak mau masuk di WTO. Tapi negara maju tetap di WTO, karena ingin ada law enforcement yang lebih kuat. Sementara kalau tidak di situ, itu law enforcement-nya lemah, kira-kira gitu. Ini jawaban kalau tidak salah menangkap, karena tadi terlalu cepat anunya komunikasinya. Terima kasih.
Oke, the next, Mas. Oke, yang paling belakang dulu ya. Ya, silakan.
Assalamualaikum warahmatullahi wabarakatuh. Thank you in advance, Nadia. Nice to meet you again. Earlier, I saw a bit of your presentation showing Mamma Mia, musical movie from musical vocal group Sweden ABBA. Because I'm a big fan of ABBA. The question is it actually difficult or not to ask permission from a non-active or disband group such as the Beatles, Queen? Because I know ABBA hasn't retired yet. Because in here in Indonesia, there are still a lot of cover music that doesn't ask permission from the original creator, even though the band hasn't disbanded yet, and even more famous than the original songwriter. Jadi untuk Pak Budi mungkin untuk kasus Felix yang suka cover-cover lagu itu ternyata beberapa lagunya tidak minta izin ke si penulisnya. Nah pertanyaannya, apakah sesulit itu untuk minta izin ke penulis aslinya? Karena ya itu tadi seperti kasusnya Once dan Ahmad Dhani mungkin gitu. Ini from perspective in UK, Europe, or in Indonesia. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Ya, covering lagu itu juga sebuah fenomena di Indonesia yang akhir-akhir ini marak sekali ya, dilakukan oleh para musisi kita. Nah, memang covering lagu sendiri punya tujuan yang bermacam-macam. Ada yang beralasan itu tujuannya adalah ya berkreativitas lah, kira-kira gitu. Jadi orang berkreativitas itu jangan dibatasi, biarkan saja gitu ya. Tapi ketika kreativitas itu sudah bergeser, orientasinya adalah mengambil keuntungan ekonomi, disitulah mulai jadi persoalan. Persoalannya apa? Selalu dikatakan yang bersangkutan itu diduga melakukan pelanggaran hak cipta. Karena apa yang di covering itu adalah musik dan lagu milik orang lain yang dilindungi oleh undang-undang hak cipta. Nah, tadi pertanyaan masyarakat, apa sesulit itu untuk dapat izin? Sebenarnya enggak, gitu ya. Apalagi di era keterbukaan seperti hari ini ya, lewat teknologi internet. Mestinya kalau mau preventif, yang bersangkutan mau covering lagu, itu minta konsensus dulu dari si pemegang hak ciptanya, dengan cara apa? Melakukan komunikasi terlebih dahulu untuk meminta izin. Dan itu bisa dilakukan lewat email, lewat telepon, lewat media sosial yang dimiliki oleh pencipta musik dan lagu tadi, gitu ya. Artinya itikat baik kita untuk meminta izin itu harus dilakukan. Jadi jangan sampai lah ini kan untuk kebebasan berekspresi kira-kira gitu ya. Kebebasan ekspresi oke, tapi kebebasan ekspresi itu kan sesuatu yang tidak boleh melanggar peraturan perundang-undangan. Maka ini harus ada izin, gitu ya. Nah, setahu saya kalau itu dilakukan itu tidak akan mengarah kepada dugaan pelanggaran hak cipta. Tapi mungkin yang jadi soal, kenapa praktek covering lagu itu sekarang marak sekali? Bahkan tidak berizin tadi. Ada dua kemungkinan. Memang tidak ada itikat baik. Dia tahu itu harusnya ada izin, tapi tidak ada itikat baik. Dan yang kedua, bisa jadi memang dia tidak mengerti aturan hak cipta. Soal kesadaran lagi. Kesadaran hak ciptanya. Musisi itu apakah sudah baik atau tidak. Nah, bagi yang pemula-pemula, saya lihat dugaan saya itu kesadarannya ya rendah. Disinilah benturannya menegakkan aturan hak cipta dengan kesadaran hak cipta yang rendah, akhirnya praktek-praktek pelanggaran hak cipta menjadi tinggi. Makanya saya selalu katakan, kalau ingin memperkuat sistem hak cipta, edukasi hak cipta itu harus diintensifkan. Saya kira gitu ya, Mas Raka.
Yeah, little one. Yeah, little. In the Netherlands, we have also some. There's a music maker, Marco Borsato. Now his name is a little bit controversial because of a scandal in 2022. So if you talk about Marco Borsato, I think it's not wise to mention his name now. But in the past, he was very famous because he made a lot of Dutch songs, and when a friend of mine was on vacation in Italy, he was thinking, oh, that are the songs of Marco Borsato, but those were Italian songs. Marco Borsato has an Italian background, and he copied a lot of famous Italian songs, but then wrote Dutch lyrics for it, and it's a sort of plagiarism. But I'm not sure if those artists from Italy have filed complaints against him. Also, I don't know because I'm not a lawyer what the rules are. If you use a song from, let's say, an English song, and you write your own lyrics in your own language. Let's say, Bohemian Rhapsody of Queen, but then in Bahasa Indonesia or in Japanese. It's really content, of course, but I don't know if you have to pay Brian May and all the others some money for the copyrights. I don't know. I think they lost it. Oh yeah, about Queen, they were very happy with the movie Wayne's World. They used without authority the song Bohemian Rhapsody. And it was not that they filed a complaint, but they were very happy. Thank you for using our song. So sometimes, it is, the artist can also be more lenient. But I think, what if it's about translating and also reinterpreting lyrics from famous songs into your own language. There is also a lot of creativity. So this sort of a gray area, I think. But Marco Borsato, his music is a lot of copy paste, but then with his own interpretation in Dutch of Italian songs.
Thank you for your question. So Mamma Mia is a good film. I agree with you. So when you think about Mamma Mia, there's lots of copyright. The screenwriter gets copyright in the screenplay as a literary work. The director and producer get copyright in the overall film, as well as accompanying soundtrack. The musician gets copyright in the soundtrack. Because it's a musical, the lyricist gets copyright in the lyrics. The record producer gets copyright. So you've got all of these different copyright owners. The famous actors, Meryl Streep, gets paid for her role, but she doesn't actually own any of the copyright. So copyright gives you royalty. So once it's released on the cinema, you get copyright protection. So you have legal streaming, but that legal streaming only gives very little revenue. And this is why you see all of the strikes and all of the issues with that. So there's legal streaming, which gives you some copyright protection, but then with illegal streaming, it's too difficult. How do you control it? So if you look at the size of the population of Indonesia and the level of illegal streaming, how do you bring that down? How do you justify charging US copyright value in Indonesia? Because you've got a difference in the pricing value and the difference in what the currency is. So you've got a lot of challenges with protecting US film in Indonesia, because your platforms, you'll have legal streaming platforms and you'll have illegal streaming platforms. Now, the illegal streaming platforms, rather than the consumer, what the US Copyright Protection IPO office want to do is shut those platforms down. So they will use GDPR, they will use data protection, they will use data privacy and all of the tools available to them to shut those platforms down. So you often see illegal platforms keep changing because they can't survive for so long. And then the other issue is it impacts royalties, it impacts revenue, but also there needs to be some system in place that not allows it, but gives an alternative. So it's a lower price bracket, but there's some value. So that, because at the current level, the cost is too high, and then that cost needs to be brought down for the copyright to be used outside of the US. And also they mitigate this into their costs. So this is why when you go to the cinema to watch the film, it's very, very expensive, because that they know there's these piracy outlets out there which is impacting it. But if that's something that AI could be a good source for, so AI could be used to detect and close down, that would be good. But then also you need to look at the cost of the legal streaming portals as well, and how that impacts like Indonesia, for example, compared to the US. But it's a very good film, so keep watching it.
Thank you so much, Nadia, and thank you so much, Mas. Is there still? Okay, but you have to save your questions for our next round because Professor Peter Meze already joined us by Zoom meeting. Okay, let's move to our next speaker. Professor Peter Meze, are you joining us? Okay, are you with us? Yeah. How are you, Prof?
Nice seeing you guys.
Okay, nice to meet you too. Okay. I will briefly read Professor Peter Meze profile. Name is Professor Peter Meze. He is Professor of Law, Faculty of Law and Political Science, University of Szeged, Hungary. He has many publication. His recently publication entitled "The Digital Intellectual Property Challenge Revisited: File Sharing and Copyrights Development in Hungary." Professor Peter Meze will deliver a speech on the topic issues of copyrights protection and publisher rights in the digital transformation era. Prof. Peter, you have 20 minutes to deliver your work, so the screen is yours.
Thank you very much for a very nice introduction. Please confirm you can see my presentation. Most probably, yes.
Yeah, yeah.
Okay,
Yeah.
wonderful. First, let me thank you. Thank you, all the organizers, to invite me and put me on the panel. I wish I could be there, but admittedly, I am currently in Malta following a very nice conference here on NFTs, and so it was simply impossible for me to present my research in Indonesia. Although I have very warm memories being there. I was there approximately 10 years ago, and well, maybe soon I can return to the country. When I got this invitation, I happily accepted that very quickly, and I offered a topic which could very properly fit into the scope of your or the scope of your conference, which is on robojournalism and copyright. A research which I carried out quite recently with a wonderful colleague of mine, Alina Trapova. We two teamed up to raise a question back in around 2021 to finish in around 2022 with this paper, to raise a question whether robojournalism could lead or should lead to copyright protection for the benefit of news agencies, corporations, or maybe even the human contributors to the publication of reports, news reports, articles generated with the help or by the artificial intelligence algorithms. This presentation today is going to be structured as follows. I'm going to give a very short introduction to the background to AI-generated works, especially the copyright focus, the copyright issue with respect to robojournalism. I will give you a very brief introduction to the technological perspectives of natural language generation applications. How do they overlap with the journalistic activities? And finally, I'm going to sum up with the empirical findings we have with respect to the business realities of robojournalism primarily in the European ecosystem, and our findings with respect to the media and communication studies related to journalistic understanding of artificial intelligence, journalistic understanding and use of robojournalism in their daily routines. To put it differently, do journalists fear of algorithms? I think our findings are quite clear. There won't be big surprises, by the way. But anyway, let's start with this presentation with the background information related to robojournalism. There's no big surprise when I state that AI and AI-generated works are present quite clearly in the art, music, and literature segments of copyright. Indeed, research has been carried out quite frequently in these fields. If you just try to look for international copyright research, you would most probably find papers speaking about the effects of artificial intelligence on the music industry, on the generative AI in the field of textual contents. Since last fall, we have seen quite a lot of news reports, by the way, but also research related to text to image, text to music, text to text, generative AI applications. We have also seen some practical hints about the relevance of robojournalism through news reports per se, confirming that artificial intelligence might be relevant in the fields of data-intensive segments of journalism, especially sports weather forecasts and financing reports of journalistic activities. We also saw some summaries about the possible benefits of journalism's robojournalism, which is primarily focusing on the positive effects regarding fast content production, expanding the news coverage, as well as leaving journalists more time for creative and investigative journalism. But we rarely found substantive copyright, especially empirical research, with respect to the question whether humans could be replaced by artificial intelligence in the journalistic area, and what the copyright consequences of that possible replacement would be. In other words, back in 2021, with Alina, we spotted certain lack of literature, gap in the literature, that we wanted to fill up with both doctrinal as well as empirical analysis. Alina was very kind to take over the role with respect to the doctrinal, theoretical background of the question. She carried out a very detailed summary of the EU copyright law focus, as well as giving very nice quick overview. Again, I must stress, at the time we did this research at the time of the entry into force of the brand new legislation with respect to press publications, the new right related to the press publications in the European Union. So, focusing on these two aspects, we summed up, and we today it's only me, but I sum up and shortly introduce the European status quo, European actual situation with respect to copyright protection and related rights protection to news-related outputs. We all know, I think there's no clear difference between Indonesia and the European Union in this aspect, that copyright protection exists in works of authorship. Works are original works of expression. It can be different jurisdiction by jurisdiction what are the exact requirements of being protected under copyright law, but it's typically creativity, originality, human contribution to the creative phase. In the European Union, currently is the general understanding that only human creations can get copyright protection. Of course, that's a very tough question. What amounts, what substantive contribution humans should do in order to generate protection for the output? How much human contribution we need? That's the real issue here. As you will see, that's a relevant question, very relevant question in the field of journalism. But on a theoretical level, we can confirm, as long as there's a human cause behind the creation of the content, you are safe to have copyright protection. Since 2021, we have an effective directive in the European Union, which also introduced, again, introduced in 19, but the effective transposition date is was 2021. It introduced a brand new press publication right as a right on press publications. This new right guarantees a certain level of protection only for 2 years, only for a limited scope, but anyway, guarantees a certain related rights protection for news publishers against those big corporations platforms which without typically obtaining permission to give access to news reports, provide this service through hyperlinking activities. In any case, in the European member states now, we have this right, which, by the way, I have to stress again, is not a copyright, it's a related right. It's a related right, which means that we do not protect the originality, the creativity of the activity, but rather the business, the investment of the service provider. This can seriously have a broader implication for us, but I must stress, we did our research at a very early phase of the implementation period of this new related right. So we purposefully eliminated the empirical analysis of this right in our research. We would practically find nothing, I must say, at that time. We left this question open. At some point, I will be happy to team up again with Alina to do some empirical research on robot journalism and the new related right, because we believe, at least we argue, that in our paper, that there is some ample space to fit robot journalistic outputs into this new related right. If that's the case, then that's an easy solution for any kind of journalistic activity to be covered by related rights, not copyright, but rights related to copyright. You understand this? We carried out a little bit broader analysis with respect to the originality of journalistic activities, and actually we found, based on the Court of Justice case law and of course based on the legislative norms we have in the European Union, that, by the way, very interestingly, not even all journalistic activities are covered by copyright. So if you are trying to find the proper starting point for protection of robot journalism, the starting point immediately says that in the European Union, not all human activities are covered by copyright. There are limitations, especially due to the style, the length, the grammar, actually due to the journalistic in-house norms with respect to the creation of the outputs. It's not necessary that all news articles are creative enough. The vast majority of journalistic articles are depending upon the pure and clear stylistic and proper grammar presentation of a certain fact. So in many cases, journalism immediately lacks copyright protection. So that's the starting point. So can we have more for, copyright for AI generated or assisted activity? You have to know, you are most probably familiar with this. AI technologies can be quite relevant in various dimensions of a daily routine. AI can be so-called generative AI, which practically means AI creates the media content. It can be assistive, which means the generation necessitates a very serious and deep involvement of human contribution. And AI technologies can also be declared to be distributive, which is much more about the spreading, the dissemination of the content. We have to stress our main focus was primarily on the generative and assistive technologies. In other words, we wanted to check how much human contribution is needed on a daily basis, practically, with respect to the creation of journalistic outputs. And of course, then we could raise a question, and is there copyright protection? To carry out this research, we decided to have a methodology that focuses on three questions. First, technological realities, business realities, and we also wanted to check what media and communication studies find about the understanding of the people involved in journalism. So what's the internal interpretation of presence of AI? I must also stress these researchers carry out primarily in 21-22, primarily 2021. So it's a kind of old in the sense that we of course have the understanding of GPT-3 by the way, but not ChatGPT yet. ChatGPT came only last year, following the conclusion of our paper. So, summing up the three main points here, with respect to technology, we saw that in the field of journalism and in the use of photojournalism, there are various very important technological and professional steps where AI can come in and where AI is very much used in the form of natural language generation applications. So, for example, content determination, discourse planning, sentence aggregation, lexicalization, referring expression generation, as well as linguistic realization. All these points are very relevant in the final creation of a journalistic work. In the old ages, all these activities were carried out by the news agencies, the chief editors, the journalists themselves, then of course various editors who worked on the linguistic and lexical polishing of the activities, of the output. From these six parts, technological or procedural steps of journalism, we actually ended up arguing that many of these, actually two are highlighted in red, but we are quite clearly believing that at least these two are de facto outside of the scope of copyright law. The other topics have clear overlaps with copyright, like content determination. That's very much in line with the idea expression dichotomy, which means that you can have very factual ideas, but you can have very creative expressions as well. So it's a question of fact, it's a question of degree as well. And of course, linguistic realization is the most important part of writing. And if it's carried out creatively, your output is most probably protected by copyright. So if you just look at these steps, the more human contribution you keep in the age of AI, the more probable that the output is connected to a single or more people and therefore protected by copyright. But it's not self-natural that there will be copyright protection, because that's our conclusion with respect to technology, that many steps of the technological realization of a journalistic activity are dependent on quite factual, quite technical nature activities. With respect to business realities, I have to speed up my presentation. We have carried out a targeted empirical analysis. We selected 10 service providers from primarily European countries, not EU. As you see, we have UK companies as well, European in general, but not American corporations. And we checked what service do they give what service do they give and to whom, by the way. We had 7 variables. What kind of software, what kind of service do they give? How much human involvement do they necessitate? What kind of languages do they offer their service in or on? Who are the confirmed clients? What sectors do they service? What parts of journalism do they serve, if they serve journalism, and whether their terms and conditions are available on their websites. We found very, very broad information out there. Many, by the way, most of the service providers work as software as a service, so they do not provide content. Content must be generated by the companies applying these applications or subscribing to these services. So in other words, the big companies doing or offering robot journalism services only give the framework. You have to fill up with content. The majority of them are so-called fully and automated services. In other words, you can use quite independently of journalists these works, but because these are mainly, as I said, software as a service rather than content as a service, you still need human contributors. And they offer a huge variety of languages, minimum 6, maximum 120. That's big, of course, but we are uncertain about the language quality. That time again, 2021, we were uncertain about the language quality of the service of these companies. By now, in 2023, with ChatGPT and GPT-4, by the way, it's almost quite clear that you can use these services at a high level, high quality in many languages. Finally, the focus on journalism, we found that there are many services having big clients and from the journalism industry, but they are practically using these services as imagined, as found by literature review at an earlier stage. They use these services primarily for data-intensive fields of journalism, sports, finance, and weather forecast. And by the way, a very interesting thing, we didn't find the terms and conditions in 4 cases. Only 6 service providers offered access to their terms and conditions. In other words, we practically didn't see every condition out there. We are uncertain in certain cases what are the business connection between the service provider and the news agency. So under what terms and conditions do they work together? It's bad because it could have been great to know this part of reality as well. And finally, one more point, media and communication studies perspective, we found that journalists, check this out, do not necessarily fear of AI. They primarily look at AI as an assistant and a supplement rather than as a replacement method. They don't necessarily fear of software generative AI because they believe that they still create more meaningful outputs wherever intuitive writing is necessary. Indeed, publishers look at AI also from a completely different perspective. They don't necessarily want to replace their journalists, but they prefer the speed and accuracy of artificial intelligence. They believe artificial intelligence is quite useful to expand the broad and so the spectrum of their activities. And at the same time, very importantly, many service providers, content providers, find AI expensive. Admittedly, signing up to these services, which I mentioned to you, is a lot of money. And a lot of money plus a need for brand new workers. So in other words, journalists might, some of them in the field of sports, for example, might lose their job, but they can be put to another branches of journalism. At the same time, news agencies have to hire brand new type of people with brand new skills to use AI. In other words, this is a lot of money, and not every agency can do this, only the big ones. And finally, readers, consumers' perspective, many people expect higher quality, quicker, broader access to information. But on the other hand, we also require, it seems so, more transparency, more trustworthy, and higher quality content. Very interestingly, with more AI comes more burden. And that's very interesting finding. It's not the same for human stuff. We are just get used to news reports by human, there can be mistakes. But if it's about AI, we need perfect We need perfect outputs. That's at least the finding of media and communication studies researchers based on interviews and other empirical activities. And it's very interesting. In other words, conclusion. We believe, based on the analysis of law, technological, business realities, and media and communication realities, we believe that there's nothing that would justify the introduction of new copyright protection for robot journalism. The current anthropocentric copyright system is perfectly fit for the age yet, because of the dire need for human contribution in journalism. If we need to find positive implications in robot journalism, that's certainly not the copyright aspect of the question, but about the speed, accuracy, spectrum, breadth and depth, as well as liberating journalists to do more quality activities in other fields. In other words, our doctrinal and empirical findings confirm that robot journalism is a great extra rather than the new threshold. And I think I stop here. Thank you very much for your patience to listen to me. Here is a link to our paper. If you're interested in that, you can find it online.
Okay, thank you so much.
I'm open for your questions.
Give big applause for Professor Peter. Okay, thank you. From Prof. Peter presentation, I noted some points. First is the benefit of robot journalism as one of the background of journalism as priority domain, including fast content production mechanism, expanding news coverage, leaving journalistic more time for creative and investigate journalism. And second, is also related to the issue of copyrights, that first, only human get copyrights protection. That the second, not all the output of journalistic should receive copyrights protection. And also, Prof. Peter explained about the implication of artificial intelligence for journalism. Okay, this is a Q&A for the second rounds. I invite first for the offline participant, Mas. Yeah, please mention your name and institution. Yeah. Wait. Hold second.
Ingin bertanya kepada Prof. Budi, apakah motif-motif tenun daerah-daerah yang sangat tradisional yang beragam itu bisa didaftarkan sebagai haki, gitu. Mengingat motif-motif itu digemari secara internasional. Misalnya kemarin motif tenun di Lombok itu diadopsi oleh artis Ivan Gunawan, desainer di fashion internasional itu, dan itu menang itu. Apakah itu bisa di-HKI-kan atau IPR-kan? Kalau bisa di-HKI-kan, itu kan tidak diketahui siapa pencipta itu. Nah, kalau bisa di-HKI-kan, siapa pemegang hak eksklusif dan fleksibilitasnya itu.
Oke, sorry Mas Eko, itu maksudnya apakah traditional knowledge, apakah GRKF itu ya?
Iya, motif-motif tenun gitu, kayak batin dan kain-kain daerah itu. Gitu. Apakah itu bisa di-HKI-kan? Mengingat salah satu juga mungkin di Bali itu kan ada motif tenun itu diminati oleh brand internasional juga itu kan. Apakah bisa di-HKI-kan, dan itu pemegang hak kekayaan intelektualnya itu hak eksklusif, hak fleksibilitasnya itu siapa? Terima kasih.
I already got your point. I think it's specific for Prof. Budi. Please, Prof. Budi.
Good question, yeah.
Okay, thank you very much. Saya coba jawab ya, Mas. Jadi ini sebenarnya out of context ya. Kita sedang bicara tentang copyright, journalism, and digital transformation era, apa Pak? Jadi kalau pertanyaan tadi itu masuk di isu traditional knowledge ya, atau pengetahuan tradisional, dan itu di Indonesia pendekatannya ada dua. Ada ke intellectual property right, ada yang non-intellectual property right. Kalau yang intellectual property right itu nanti masuknya di undang-undang cipta, motif-motif tenun, ya. Dan sekarang pemerintah sudah mengeluarkan peraturan pemerintah mengenai kekayaan intelektual komunal, ya, dan itu mencatatkan ke negara. Tetapi itu harus disiapkan dokumentasinya terlebih dahulu. Dokumentasi atas motif-motif tradisional tadi disiapkan sesuai dengan aturan tadi, lalu dimintakan pencatatan kepada Dirjen KI. Nah, sebenarnya nanti soal pencatatan ini akan ada kaitannya juga dengan pendekatan non-intellectual property right. Nah, tapi saya jawab lewat intellectual property right dulu. Selain itu juga bisa masuk ke geographical indication regime, rejim indikasi geografis, yang itu diatur di Undang-Undang 20 tahun 2016 mengenai merek dan indikasi geografis. Nah, itu bisa melalui ketentuan indikasi geografis. Nah, yang non-hakinya itu ada namanya Undang-Undang Pemajuan Kebudayaan nomor 5 tahun 2017. Di situ juga sama sebenarnya dicatatkan untuk ditetapkan oleh Kementerian Kebudayaan bahwa motif itu merupakan motif milik daerah tadi, kira-kira gitu. Nah, itu sudah banyak dilakukan juga oleh pemerintah daerah, termasuk yang ada di DIY ini. Kita sudah mencatatkan sekitar 42 pengetahuan tradisional yang ada di DIY. Nah, kalau itu mau ditempuh oleh pemerintah daerah di Nusa Tenggara Barat, itu juga bisa dilakukan. Jadi pilihannya cukup banyak. Kalau kita mau bicara tentang bagaimana memproteksi pengetahuan tradisional tadi, atau itu lebih spesifik lagi isunya ke tradisional expression cultural. Jadi itu kaitannya dengan ekspresi budaya tradisional. Saya kira itu, Mbak Indah.
Dr. Ewat, want to give some information, some perspective about traditional knowledge existence in your country, maybe? Or Miss Yundit, yeah.
So in the UK, in terms of traditional knowledge and geographical indications, it really can add value to products. So we have a lot of geographical indications, and that means in the name of that trademark of that product can only be used when it comes from certain locations. So there's a lot of overlap between what traditional knowledge and geographical indications can do for batik in Indonesia, because what the IP allows is for you to increase the value of your traditional knowledge. So you have traditional knowledge, but how do you get the intellectual property value from it? So at the moment, you have a lot of traditional knowledge in Indonesia, but you are not tapping into the IP value of that traditional knowledge because culturally it's shared, because the understanding is that it's everybody. So it's a shared commodity. But for intellectual property, you need to protect the name, and that protects the essence of what it is. Through a geographical indication, you can pinpoint the origin so that you can't have batik in the US or you can't have batik in Nigeria, because it has to originate from Indonesia. And then they cannot use the word batik. So if they do a similar design, it has to have a different name. That's how you protect the value. So then when you are selling, so in terms of the economy, you see the name batik and you know, this is from Indonesia. But if it's not protected, anybody can use the name, especially in different countries. So the value attached to it has to come from your Indonesian intellectual property office to establish the value of your traditional knowledge and geographical indications. That then dictates the price of what that product can be internationally. So there's a real untapped value in your traditional knowledge and geographical indications. In the UK, we are very, very good at protecting them. So when we do our international agreements, so you all know we have now left the EU officially. Sorry to the Netherlands, but it wasn't my decision. Um, what now happens is we are now negotiating our own trade agreements. Within that, the UK works very hard to protect its traditional knowledge and geographical indications. Now, that needs to be a level playing field. So at the moment, we've got a free trade agreement with the Gulf, so the GCC, and we're doing a free trade agreement with them. So we are saying to them, you need to protect our geographical indication. Now, in that conversation, when the UK and Indonesia come to do a free trade agreement, Indonesia need to be saying, but you in the UK need to protect our geographical indication as well. So it's not one-sided. So both sides are saying, we have traditional knowledge, we need it protecting. But then from a national point of view and a regional point of view, each region needs to protect its IP first, and then you can protect it internationally. So that's what we do in the UK. We have protected our geographical indications. So they're registered in the UK IPO, they're registered in the EU IPO, they're registered in the US IPO, and regionally we have that protection. And that's why the World Intellectual Property Office is so good. You will have a representation from Indonesia that sits on the WIPO General Assembly, and your WIPO General Assembly representative needs to be advocating for traditional knowledge and GI in Indonesia, because the most famous GIs that you hear of are not from Indonesia. So when I think of geographical indications, I think about the French and how they protect their geographical indications. Australia are very good at protecting their geographical indications, and they're your neighbor. So there's a lot of exchange between Australia and Indonesia. So that's a great opportunity to have that discussion on how they protect it and what you can learn as Indonesia, because it's about that learning. You can't, if you don't have the same number of years of intellectual property protection, you're constantly catching up to the Western countries. So what can you do to learn and then implement that in your own intellectual property strategy? Because that will be really important, especially like, you've heard from Professor Peter as well about the digital environment, also from Professor Budi, that is changing. So what if Batik becomes digital? Then what do you do? If you don't protect it offline, how are you going to protect it online? Yeah. So these are really good questions, but as students, you guys need to be thinking about how can you make this happen? How can you implement it? How can you be part of the strategy? Can you do some data collection? Can you do surveys? How do you enhance it? So it's a great, I know it's not there yet and it's a challenge, but it's also a very good opportunity.
Okay, thank you so much. Let's give big applause for all of our speakers. I think it's quite comprehensive explanation and also comprehensive answer for all of the speakers. And ladies and gentlemen, this is the end of our seminar agenda today. On behalf of the committee, I would like to say thank you to all the participants. See you on the next occasion. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Ms. Indra Hadian and our distinguished speakers. Would you please remain in the stage, because our final agenda for this morning is the handing over of token of appreciation from both of us, from the Faculty of Law, Universitas Islam Indonesia, as well as from Hukumonline. And for that, we would like to request the Vice Dean, Mr. Agus Trianta, PhD. Would you please step up to the stage? And Farah, Miss Farah from Hukumonline also, please. we will start the handing over ceremony with Dr. Nadia Naim. Please, our Vice Dean will hand over our little token of appreciation. Followed by Dr. Ewood Clay. It will also be handed over by our Vice Dean, Mr. Agus Trianta, PhD. And certainly, last but not least, our own Dean of Faculty of Law and the final speaker, Professor Budi Agus Riswandi, which will be handed over by Ms. Farah as the representative of Hukumonline. Thank you once more for our Vice Dean, for Ms. Farah from Hukumonline. We can never thank you enough, our distinguished speakers, Professor Budi Agus Riswandi, Dr. Iwet Clay, Dr. Nadia Naim, Professor Peter Meze, all the way from Hungary. Thank you for our moderator, Ms. Indara Hadian SHMH. And that is the end of our international seminar this morning. Thank you so much for your kind attention, appreciation, and questions. On behalf of the committee, I would like to extend our apology and thank you once again. Assalamualaikum warahmatullahi wabarakatuh.